Anti-2A judges in lower courts have been faking confusion about Bruen. They've been begging for guidance, claiming the law is too murky, the standards are too complex, whatever. Funny thing is, the Supreme Court has actually been listening and figuring out a way to turn the tables on everything the anti-gunners thought they've got a tight grip on. Today, we'll talk about a Supreme Court case that has nothing to do with guns on the surface, but quietly delivers a haymaker to the leftists' anti-gunner playbook. What started as a Medicaid funding case just lit up the legal road ahead for Bruen-style rulings. We're going to break down what the left tried to pull off, how it backfired, and what this means for upcoming Second Amendment battles in states like California and Illinois. We'll look at how every complaint, every "we are so confused" soundbite is about to blow up in their faces because SCOTUS isn't backing off. If you care about your 2A rights, this might be the best legal news you'll hear all year. The case I mentioned is Medina vs. Planned Parenthood. The ruling on it dropped like a friggin' sledgehammer. I don't think there were a lot of people in the community who caught its deeper meaning at first glance. Remember the phishing case that we reported on back in 2023? Loper Bright Enterprises versus Raimondo? It's got nothing to do with the Second Amendment on paper, right? On the surface, nope. But the Supreme Court used it to nuke Chevron deference. In a 6-2 ruling, they said lower courts must stop blindly siding with federal agencies like the ATF whenever a statute is vague. That means the ATF can't just reinterpret laws however it wants anymore. Just because the Congress didn't spell something out doesn't mean it's up to the agency to guess or invent stuff. That's huge for gun owners. It guts the legal crutch the ATF has leaned on for years to push bans and rule changes without new laws. But I digress. So what does that phishing case have to do with Medina? Let's circle back to Medina. On paper, it looks like it's just another boring Medicaid funding fight. South Carolina didn't want any state or federal pennies sliding toward Planned Parenthood, even for services that had nothing to do with abortion. Activists ran to court, waving the words, "any qualified and willing provider," claiming those 5 words meant patients and clinics could sue the state for blocking the cash. The Fourth Circuit agreed. Judge Harvey Wilkinson practically wrapped the phrase in neon and called it a private ticket to federal court. Then the Supreme Court took one look, snatched the case, and said, "No, that phrase doesn't give you a private cause of action." 6-3, done and done. That alone stings for the abortion lobby, but the real shockwave hides in the reasoning. The justices spelled it out in black and white. Lower courts claimed they were baffled by the statute, complained they needed guidance, and the High Court obliged, clearly, firmly, and in a way the left absolutely did not want. That dynamic should ring a very loud bell if you've been following Second Amendment litigation since NYSRPA, pronounced Nye Sur Pa, ver and Bruen. Ever since Bruen imposed its text and history standard, anti-gun scholars, certain judges, and a chorus of op-ed writers have insisted they can't function under the new rules. They cry that they're not historians, that 18th century analogs are obscure, that the founding era bears no resemblance to society as we see it today. It's an orchestrated fog bank designed to muddy the air until courts grow frustrated and default to the old interest balancing tests that always favor restrictions. Medina shows how that gambit can implode. When enough jurists cry confusion, the Supreme Court doesn't shrug and hand the steering wheel back to them. It steps in, writes the roadmap itself, and cements standards even harder than before. Planned Parenthood's funding hopes just crashed on that reality, and gun control strategists should be sweating. Lots of federal judges have already tried the confusion routine in gun cases. There was even this one guy who went as far as to lament from the bench that he was never trained as an archivist while weighing a mag capacity lawsuit. Others have griped in written opinions that the historical record is too messy, that contradictory statutes from 1791 and 1868 leave them paralyzed. Those laments made headlines in the Trace, Vox, and every Giffords press blast. The chorus grew loud enough that the Brennan Center compiled a running list of decisions where jurists threw up their hands. The message was simple. Bruen is unworkable. Please send help. Medina proves the justices are listening, just not in the way anti-2A progressivists hoped. Remember U.S. v. Rahimi? The Fifth Circuit tried to apply Bruen to a federal gun ban covering individuals under domestic violence restraining orders. They struck the law down, reasoning that the government failed to dig up a sufficiently analogous founding-era restriction. Critics howled that the court had unleashed dangerous abusers and that Bruen had turned judges into amateur reenactors, thumbing through dusty statutes. The Supreme Court accepted the case and, crucially, didn't toss Bruen overboard. Instead, the majority said, "Here's how you do historical comparison the right way," and reinstated the prohibition. Gun control groups called it a victory, but they missed the fine print. The court adjusted the mechanics while leaving the original standard intact. That's clarification, not retreat. Exactly the pattern Medina just repeated. The same script played out when the High Court yanked Duncan vs. Bonta, the California magazine ban challenge. After Bruen arrived, the Supreme Court didn't affirm or reverse. It vacuumed the decision off the books and mailed it back with a sticky note. Try again. Apply Bruen correctly. That's a giant neon warning to every circuit judge tempted to claim intellectual vertigo. Mess this up, and the 9 justices will rewrite it for you, probably in language far less friendly to sweeping restrictions. Why do anti-gun strategists cling to the confusion tactic despite these warning shots? Because it worked for decades under the old tiers of scrutiny regime. Judges balancing governmental interests against individual rights could nod at a public safety statistic and rubber stamp nearly any limitation. Bruen smashed that shortcut, so sowing doubt is the next best play. The problem is that originalism isn't going anywhere. The court's conservatives are committed to reading the Bill of Rights in the light of its ratification, not modern policy polls, and every time hostile judges feign bewilderment, the court gains an excuse to write longer, sharper opinions, locking the standard in place. Medina also exposes a deeper structural issue. Section 1983 litigation hinges on whether Congress created a privately enforceable right. The court set a precise 2-step test decades ago, yet multiple circuits drifted, invented carve-outs, or amplified dicta until the doctrine blurred. When South Carolina called their bluff, the Supreme Court reminded everyone of the original framework. No balancing, no penumbras, just statutory text and context. That's the same philosophy that empowers Bruen. Gun control idiots hoping the court will grow sympathetic to pragmatic arguments haven't been paying attention. Pragmatic balancing is the very thing this court distrusts. Consider how these threads converge. Lower courts assert confusion about Bruen. Media outlets amplify that confusion, creating public pressure. Advocates urge the High Court to fix the mess. The court grants review. Then, rather than dilute originalism, it reaffirms it, just more clearly. Anti-2A litigants lose ground they never expected to contest, and pro-2A precedents solidify. The playbook is literally backfiring in real time. Medina's outcome makes the pattern impossible to ignore because it involves a completely different constitutional context. If the court protected a state's power to defund Planned Parenthood by clarifying an obscure Medicaid clause, imagine the resolve when the explicit language "shall not be infringed" is on the table. Some commentators argue that Rahimi shows the conservative bloc can bend, but even that decision underlined the supremacy of text and history. The majority didn't pivot to intermediate scrutiny. They searched early republic laws for disarming violent threats. They found enough analogs and kept the framework intact, so we can expect the next 2A case to cite Rahimi alongside Medina. See, we told you historians can guide us if you bother to read them properly. The anti-gun lobby thought Rahimi blunted Bruen. In truth, it gave Bruen teeth by teaching lower courts how to chew. California's policymakers are already feeling that bite. After the Ninth Circuit received its Duncan remand, judges can't lean on public safety studies alone. They must unearth founding-era bans on cartridge capacity. Good luck with that. If they flub it again, the High Court has every incentive to reach down and finish the job, citing Medina's approach. When guidance is begged for, guidance will come, and it probably won't read the way Sacramento wants. The reaction from the Academy is telling. Law reviews now churn out essays pleading for a return to means-end scrutiny, claiming originalism breaks under the weight of modern gun technology. Yet Medina indicates the court views institutional uncertainty as a problem it can solve, not a reason to discard the standard. Every article complaining that judges aren't historians digs the hole deeper, because it furnishes the justices with proof that lower courts need direction. That direction will likely focus on pinning today's restrictions to concrete analogs or watching them collapse. All of this lands on the everyday gun owner in practical terms. Challenges to registration databases, so-called assault weapon bans, and age-based purchase limits all hinge on how faithfully courts apply Bruen. Whenever a district judge tosses a case saying the history is too muddy, Medina gives plaintiffs a new arrow. Your Honor, if this really confuses you, pass it upstairs, because the Supreme Court just proved it won't shy away from cleaning up doctrinal messes. That argument practically writes itself now. There's also a psychological shift. Anti-gun litigators used to stall with procedural wrangling, confident that the Supreme Court accepted only a handful of Second Amendment petitions each term. But with Medina, the justices signaled a willingness to spend their limited docket space correcting lower court evasion in any field. That's an invitation for Pro 2A lawyers to press harder, not pump the brakes. The more the other side wrings its hands about unmanageable history, the more likely the court will take the bait and issue a ruling that locks historical methodology even tighter. The left's lone hope is that public pressure or future appointments will swing the court. Bank on that if you want. But Medina arrived with the current lineup, and the decision wasn't even razor thin. The lovely Amy Coney Barrett joined Thomas and Alito in that 6-vote majority. That alignment proves that when statutory text meets policy controversy, the conservative wing closes ranks. Gun rights sit directly in that textual sweet spot. Betting against a similar coalition in the next Big 2A showdown feels reckless. There's an irony here few have acknowledged. By crying confusion, lower courts present themselves as humble servants asking for light. In reality, they're second-guessing the very approach the Supreme Court ordained. Medina exposes that posture as both disingenuous and dangerous to their own cause. The court's patience is not infinite. Eventually, it responds with sweeping declarations that leave no wiggle room. Planned Parenthood just discovered that the hard way, watching its Section 1983 blueprint burn to ashes. So where does that leave gun owners today? We stand on a legal landscape where every feigned ambiguity can ricochet. When a district judge doubts her ability to source 18th century parallels, she sets the stage for the Supreme Court to step in and draw them for her. Once that happens, her discretion evaporates. She's bound by a precedent forged at the top. Anti-gun attorneys, who thought confusion would give them leverage, suddenly face an even steeper climb because the clarification usually slashes the doctrinal space for restrictive rulings. We should expect a cascade effect. See, certain circuits will continue resisting, perhaps by relabeling historical hesitation as public safety necessity. Medina, though, teaches that such rebranding won't deter review. The justices didn't sidestep Medicaid politics. They walked straight through it. They won't wilt at Bloomberg-funded data on gun violence either. Original meaning remains their compass. The conversation around future cases like the Illinois semi-automatic rifle ban will likely echo Medina in oral arguments. State lawyers will insist the record is unclear. Plaintiffs will reply that any gap is a reason for the court to clarify, not punt. Observers who see that as risky for gun owners misunderstand the current momentum. Each clarification so far has either preserved or expanded the core right, never shrunk it. Confusion is ammo, and the anti-gun camp keeps loading the magazine. None of this means victories happen overnight. Medina illustrates the years it can take to reach final judgment, but it also demonstrates why perseverance pays. Planned Parenthood celebrated multiple wins on the way up the chain, only to watch the scoreboard flip in one morning. Gun owners reading bad headlines from district courts should remember that snapshot can't be trusted until the final bell, and Medina shows the final bell often rings in our favor once the Supreme Court's gavel drops. Every activist needs to internalize one tactic. When you hear a lower court judge declare Bruen unworkable, catalog the quote. Pin it to your appeal and point straight at Medina. The argument is elegant. Confusion plus constitutional stakes equals Supreme Court review, which historically equals a clarified, standard-leaning originalist. The other side paved that road. No reason we shouldn't drive it. Medina will very likely be cited in the next major gun case, not because it addresses firearms, but because it illustrates how this Supreme Court handles doctrinal whining. Complain loudly enough, and you'll get an answer. Just don't expect to like it if your mission is dismantling the Bill of Rights. Gun control strategists wished for more Supreme Court oversight. They just got a glimpse of what that prayer looks like answered, and it isn't pretty from their vantage point. For gun owners, it's confirmation that the path of original meaning is not simply intact. It's being reinforced with every ruling that arrives, draped in pleas for clarification. So here's the bottom line. Every time anti-gun judges whine about not being able to apply Bruen, they risk handing the Supreme Court another excuse to step in and hammer down a ruling that leaves zero room for gun control gymnastics. Medina showed us exactly how that plays out. Do you think judges are genuinely confused, or is this all part of a bigger delay strategy? Have you spotted any rulings that could trigger another SCOTUS smackdown? Drop your answers in the comments. Then hit like, share this with your crew, subscribe, and click the bell so you don't miss what happens next.